Okay, good morning. Let's get started. So today we're going to be talking about the estates assignment. This is the week 5 tutorial questions where we did question 2 in the tutorial and then you guys submitted question 1. And what we're going to be talking about, because I started grading it over the weekend, and initially this was very alarming. Sort of the initial reaction was deeply concerned. As I've continued grading, I am less alarmed, but still not sure what went wrong for a lot of folks. So what I'm going to do is I have a list of things that I have sort of noticed are patterns, right? Things that sort of keep happening. And we're going to go through those common errors today. And then we're going to talk about what comes next. And then we're going to take your questions. Okay, so that's how we're going to do this. And before we get started, let me just go ahead and tell you guys that you do not need to take notes here. If you do, that's fine. You're welcome to. But I will be posting this common errors document once I finish the grading, and then you'll have everything that we've talked about and anything that I find after that. Okay, so no worries on that score. Okay, so this first thing, I actually reorganized Monday. The list was just sort of like as I came up with stuff, and I kind of reorganized it this morning. And so the first thing that I want to talk about is, boy, an awful lot of you guys like really want to give me a lot more information than I'm asking for. Like, I don't need to know the history of the life estate. I don't need to know the rights of the remaindermen to prevent waste. Like I don't need to know any of that. A lot of students created more work for themselves, created more work for me because I have to read everything that you say, and didn't help themselves. And so, like, just answer the question that is being asked. Like, don't try and give me more than I'm asking for. You don't get any extra points for it. You don't lose points. You haven't hurt yourself, but you're making your life harder and you're making my life harder. So please don't do that. Here is how we format the answers to these questions, okay? When we read a conveyance, it begins by creating a possessory interest that is held by some person, right? Some entity, a holder. If that possessory interest can be terminated, if it is terminable, not determinable, if it is terminable, then it creates a future interest that is also held by a holder, and which, when it vests, creates a possessory interest of its own. And it's possible that some of these future interests will be contingent, right? So there will be a condition that has to be met for them to come into existence. And so this is how you're going to format your answers, okay? Possessory interest to the holder, and then a future interest to the holder in possessory interest, and then any conditions that have to be met. Everything else is surplus, does not need to be there, okay? And I think there's some confusion over the names of these interests and how they relate to one another. So let me give you that list. And again, this is the part where I'm telling you, you don't have to take notes. This is going to be a document that is given to you. This is going to be in a document that is given to you. Okay. There are 5 possessory interests: the fee simple absolute, the life estate, the 2 kinds of defeasible fee, the fee simple determinable and the fee simple subject to condition subsequent, and the fee tail. 5 possessory interests. We're going to talk more about the fee tail a little later. There are 4 kinds of future interests: the reversion, the remainder, the possibility of reverter, and the right of re-entry. So there is no such thing as a possibility of reversion. There's no such thing as a possibility of remainder. There may be a contingent remainder if the contingent doesn't necessarily come into existence, but there's no such thing as a possibility of a remainder. Okay. How do these 2 things relate to one another? How does the possessory interest relate to the future interest? Okay. The first thing you have to keep in mind is that the possessory interest defines the future interest that it creates. Okay, so there is 1 possessory interest and 1 future interest in existence at any point in time. Okay. When that possessory interest terminates, okay, it goes away. The future interest vests, and in vesting, it creates a new possessory interest, and then out of that possessory interest is a new future interest. And so the cycle continues, right, until someone takes in fee simple absolute. Because the possessory interest defines the future interest, you have to know which future interests go with which possessory interests. Okay, so the first thing is, right, 1 possessory interest, 1 future interest. So if you tell me that Albert has a life estate and Bob has a fee simple determinable, no, because that is 2 possessory interests at one time. Okay. So which future interests go with which possessory interests, right? First of all, if the possessory interest is a fee simple absolute or a fee tail, there are no future interests, right? Those go on forever. They have to be conveyed through a conveyance. They can't be conveyed through the creation of a future interest. The life estate can create one of 2 future interests. It can create the reversion. Sure, Isabella, sure, right? There cannot be two possessory interests at one time. So if you say to me that Albert has a life estate and Bob has a fee simple determinable, no. Okay. What could happen is that Albert has a life estate and Bob has a future interest that will vest into fee simple determinable, but Bob does not have a fee simple determinable until Albert's life estate disappears. Make sense now? Isabella? Great. So which future interests go with which possessory interests, right? Life estate has a reversion, remainder. The reversion is when the original grantor holds the future interest. The remainder is when anybody else holds the future interest. Okay, so if you say to me that Agnes has a life estate and Barbara has a possibility of reverter, no, that is not how it goes. Okay, if Agnes has a life estate, Barbara has to have either a reversion if she's the original grantor or a remainder if she's a third party. Okay? If the possessory interest is a fee simple determinable, the future interest has to be a possibility of reverter. Okay? It is not a possibility of reversion. It is not a remainder. It is a possibility of reverter. Okay. And the last one, right, is the fee simple conditional, or the fee simple subject to condition subsequent, has to have a right of reentry as the future interest. So if you tell me that Alan has a fee simple conditional, you can't tell me that Betty has a possibility of reverter. Betty has to have a right of reentry. Okay. You have to read the conveyance in the order it is written. Told you guys in the lecture that you should think of the conveyance as a timeline, right? Things happen in the order that they happen. Now, there are exceptions to this. We're going to talk about those. Now is actually a good time to talk about them. Sometimes there are conditions that determine whether there are two types of conditions, right? There are conditions that divest a possessory interest, that end a possessory interest, and there are conditions that must be met for a future interest to vest and become possessory. Okay, so let me give you guys an example. To A for life, then to B if B graduates from UE before A's death. Okay. In this case, B doesn't have a fee simple defeasible. B has a remainder in fee simple absolute because the condition determines whether the future interest vests. It does not determine that the possessory interest ends. Okay. This one's a little tricky. Does it make sense? Give me a thumbs up or a yes, no, if it makes sense. Or no. Sure, absolutely. Okay, not a problem. So this conveyance, right? This conveyance doesn't create a condition that ends B's possessory interest. It creates a condition that has to be met before B's future interest can turn into a possessory interest. So let me give you another example of the other kind of condition, right? 2A for life, then to B, but if B graduates from UE before A's death, then to C. Okay, so same condition, but because it acts as a divesting condition rather than a condition on vesting, different estate is created. No, I'm sorry. This creates the same estate. Let me give you a different. Ignore everything I've just said. Let me give you a better example that actually works the way I'm trying to tell you it works. Okay, this one works the way that I intended to. 2A for life, then to B, but if B graduates from UE, then to C. Okay? Because the key component is that the condition either is met or is not met before the end of A's estate. Okay? Now, does it make sense? Is this better or okay? Nothing to apologize for. It's okay. So I can say to somebody, you only get this land. Yeah, no, this is what I'm trying to do. Okay. I can say to somebody, you only get this land if you meet my conditions by my deadline. Okay. And if they don't meet my conditions by my deadline, then they don't get it at all. Or I can say, you get this land when this thing happens, right? Whatever it is. But if you do this thing that I don't want you to do, you lose it. Okay? And these are two different conditions. So the first one is the 2A for life, then to B if B graduates from UE before A's death. Right? You have to meet the condition before you can take. The second is 2A for life, then to B, but if B graduates from UE, then to C. You take the land, right, when the thing happens, when A dies. But if you do this thing that the grantor doesn't want you to do, then you lose the land. And that's the difference between a divesting condition and a vesting condition. So, does it make more sense now? Great, Ashley's got it. How about you, Isabella? Excellent, excellent. Okay, let me see where we are. A lot of students are missing Um, yeah, there's not, I mean, part of the problem is that indicators can go both ways, right? But basically, the indicator of the conditional fee, right, the condition subsequent, is that there is an ongoing condition that at some point will cease to be. So there, I'm not, there's not really there's not really a great list of indicators. The texts have a couple of lists. I don't like them in either book. Professor Owusu sort of acknowledges that there's kind of a problem with using the indicators. Professor Cotolini doesn't really talk much about estates. So that's the best answer I've got, Megan. I don't know if that's helpful. So one thing that a lot of students are missing is the shadow grant. And don't go looking in the text for that term, and don't Google it. I made it up. I'm going to get to that later, Ashley. The shadow grant is the retained future interest held by the original grantor. And here is sort of the test for whether there's something out there. If there is a list of events that if all of these things come to pass, no one in the conveyance owns the land, then there is a retained future interest held by the original grantor. It may be contingent, it may never come into existence, it may never vest, but it's out there and you have to account for it. Because the conveyance has to describe who owns the property forever, right? And so at some point, there has to be a fee simple absolute somewhere in the future chain of title. If there isn't, if there is some possibility, however remote, that nobody owns the land under this conveyance, there has to be an original grantor retaining a future interest. And connected to that in some ways, right, I think that there's some confusion over, like, people are conflating children and heirs. So just because someone has no children doesn't mean they don't have heirs. And just because someone has children doesn't mean that those children are their heirs. And so we have to, one of the things that you have to do is you have to game out what happens if someone dies childless, who are their heirs, what happens if someone has children, what happens, when their heirs are determined, what happens if they, outlive someone else in the conveyance, right? All of these things are things that you need to be thinking, that you need to be able to answer in how the conveyance plays out. And sort of related to that, a lot of folks, when they couldn't sort of figure out who got the land, they wanted to say that, well, the state gets it, or the crown, right? This is a process known as a sheet. I'm going to put that in the chat because it's not spelled any way that sounds like that it looks like how it sounds. But a sheet is when property has no owners and it goes back to the state. Okay. Now, I am not, this is not an estates class. We're not, so I'm not sort of reading up on estates in the Caribbean, but in the places that I'm familiar with, a sheet is incredibly rare. Let me get to that in just a second, Isabella. A sheet is very rare. Where I come from, I don't imagine that it's very common in the Caribbean either, but I could be wrong about that. So Isabella asks, when a company owns land and the owner of the company dies, who does the land go to? Will it go to the government? So this is a question that is sort of better suited for company law, and so I don't want you to sort of rely on my answer, but my experience, my knowledge suggests that the ownership of the company is a property asset, and so when the owner of the company dies, that property asset passes to whatever heirs they have. So the company still owns the land, but now there's a different owner of the company. So like the company and the owner are two different legal entities, and the company continues to exist and there's now a new owner. Okay. But again, that's a question that's better put to the company law lecturer. Okay, last few things, and then we'll sort of wrap it up and move on. The first thing is, awful lot of students think that one or more of these conveyances in the assignment creates a fee tail. I'm just going to go ahead and tell you, no, it does not. None of these things create a fee tail. In a lot of jurisdictions, fee tails are abolished, right? Even if you use language that would create a fee tail, the court's going to go, ha ha, screw you, buddy. No fee tail for you. In jurisdictions where the fee tail is allowed, it's disfavored. And what that means when we say it's disfavored, we don't assume that the fee tail is created. We require explicit, precise language to create the fee tail. So there are three types of language that if you see them, you should be thinking fee tail. And if you don't see them, you should not be thinking fee tail. Okay, so let me give you those languages in the chat. They will be in the document, the common errors document. Okay, so here they are. The first one and the most common is 2A and the heirs of his body, and it's of his body that creates the fee tail, right? If you don't have of his body, if you just have 2A and his heirs, that's a fee simple, okay? Sometimes you'll see 2A and his heirs begotten of a spouse's name, right? Mary or Barbara or whatever, right? That creates a fee tail, and even more than that, it's creating a fee tail specific to the heirs of that marriage. Okay, so it's intended to remove heirs from prior marriages or subsequent marriages or heirs out of wedlock. Just the heirs of this marriage participate in the entailed estate. And finally, if we allow fee tails at all, we will allow people to say that that's what they're doing, right? 2A in fee tail, and the court will go, fine, that works, okay? But if you don't see one of those types of languages, or you're in a jurisdiction that has abolished the fee tail, no fee tail, none at all whatsoever. Last thing that I want to go over is a few students have suggested that some of these defeasible fees have, the conditions are void for uncertainty. So I want to talk a little bit about what uncertainty is, okay? Uncertainty is not, we don't know whether this estate has ended, okay? Uncertainty is, we don't know how to determine whether this estate has ended. This came up in one tutorial when we were talking about conveyances, maybe two. And the example I gave for a condition that would be void for uncertainty is 2A, so long as they're a good person. We don't know what that means. We don't know how to define it. We don't know how to measure it, okay? So that would be a condition that is void for uncertainty. I think that some of the confusion about uncertainty is because the leading case on uncertainty actually applies the doctrine wrong. Let me explain what I mean. The case that students keep citing is a 1943 case from the House of Lords. And it correctly states the doctrine, right? It says that uncertainty is when we don't know how to answer this question. But the bequest in this case, and I don't have the name of the case handy, but I will get it it will be in the common errors document. The bequest in the case was 2A, so long as she marries a man of Jewish parentage and of the Jewish faith. And the Lord said, well, we don't know what of Jewish parentage means. Does that mean having one Jewish parent? Does it mean having two Jewish parents? Does it mean being adopted into a Jewish family? Like, we don't know how to define whether A's husband has met this condition for the bequest. And so it's void for uncertainty. And that is completely wrong and honestly somewhat anti-Semitic of the Lords, not of the students who are relying on the case, but of the Lords. Because if you ask any Jew anywhere in the world ever, they will be able to tell you exactly what it means to be of Jewish parentage. Like, that's a debate that we have, and we know the answer. Like, we know what that means. And so the Lord sort of deprive the Jewish community of the right to define itself and to define its own boundaries by refusing to sort of take into account that community knowledge. So none of the conditions in this assignment are void for uncertainty. We may not know the answer, they may not be ascertainable at the time of the conveyance, but they're not unknowable. Okay, we can determine whether this condition has been met. Okay. Okay. So now let's talk about what's next. Like I said, when I finish grading, I'm going to post the common errors document so that you guys have it. And then you are going to resubmit this assignment. We're going to take another bite at this apple because this is something that's important and we need to nail down that you have learned this so that you can sort of understand the vocabulary that we're dealing with. So that's what's going to happen next. Okay, we have 15 minutes left. What questions do you guys have? If you don't have any, if everything's clear, if we're good, we'll release a little early, but we've still got 15 minutes left. So if you have questions, now's the time. Yes, I actually had that thought driving to campus today that I meant to post the worksheet for the new topic yesterday and got distracted by, well, the fact that my country is setting itself on fire. But that, yes, I did think of that. I'm going to take care of that this morning. So, is there a difference between a conveyance and a mortgage? I mean, yes, right? Because this is a little beyond the scope of this topic, and mortgages are really, I think they're something that you deal more with in property too. But basically the mortgage is the interest held by the creditor who has, secured a loan through the property. And the conveyance is the terms by which the property passes through the chain of title. Okay. So again, you'll discuss mortgages in more detail in property too. So Shanice, the answer to that question depends a little bit. Let me finish Shanice's question and then I'll answer yours, Martina. The answer depends a little bit on which future interest you're dealing with. Okay. So future interests except for the right of re-entry vest when the possessory interest terminates. So in a life estate, when the life estate holder dies, when in a fee simple determinable, when the event happens, the future interest automatically vests. Okay. The right of re-entry vests when the condition ceases to be true, and then the holder of the future interest takes some action. Okay, so you have to have the condition, but then you actually have to do something else to take possession. Okay, and almost anything will work, but you do have to do it. If you just sort of sit on your rights, you don't own the right of re-entry doesn't vest. Okay, so Shanice, does that answer your question? Okay, what part doesn't it answer? I don't know what I don't know what the word condition means. But I think you may be asking the same question that Martina is. So let me answer Martina's question, and then we'll see if you still have a question. Okay. So Martina, you're absolutely right. Right. If a future interest is contingent, then it doesn't come into existence unless the condition is met. Okay, so that contingency has to be met before the future interest comes into existence. And if it never comes into existence, it can't vest. Okay, so anytime you identify a contingent future interest, you should be aware, you should be asking what happens if this contingency is never met. Like what, because there has to be something that happens if the contingency isn't met. There has to be something out there that sort of steps into the shoes of that. Okay, great, awesome. Okay, so Martina, does that answer your question? Great, awesome. Okay, so what other questions do we have? Okay, going once. Can I clarify heirs from children? Sure, right? So think about it. I do not have to bequeath my estate to my children. I certainly hope not, because I don't have any. Right? I can give my estate to the Red Cross or to the UE Alumni Association or to the Church of Jesus Christ of Latter-day Saints, right? Or to you. Don't expect that. So I can name heirs that aren't my kids. So just because I have kids doesn't mean that they're going to be my heirs. We can assume that they're likely to be, but they might not. And what happens if they're not? And just because I don't have kids doesn't mean I don't have heirs, because I could name any organization or any person as my heirs. Okay, and even if I die intestate, right, without a will or without a mechanism for devising my estate, there are structures in place for determining who my heirs are, even if I don't have kids, right? My parents, my siblings, my nieces and nephews, all of these people could wind up being my heirs. Actually, in most jurisdictions, I think the spouse has first priority. A surviving spouse has first priority, and then kids. But you're correct that if there's no specification and there's no surviving spouse, then yes, children sort of are the first in line. So, okay. What other questions? Honestly, and boy, do I hate saying this. I think that's a question for family law. And I hate saying that because I'm tutoring family law, and boy, is that just a giant pile of suck for me. I am not doing well in that class. The third years all hate me. But the answer to the question is that in the places that I'm familiar, if the divorce is not final, the spouse can usually claim a spouse's share, even if they're in the process of getting a divorce. So yeah, the answer is that the spouse, again, that's a question for the family law lecturer. So I don't really have an answer for what happens in that case. Okay. So what other questions? And I should go ahead and tell you guys, right, that you do not have to worry about these sort of in-between family law cases in this class. Okay, I will not ask you about cases that turn on whether the divorce is final or not. Okay, that will not be an issue in this class. Okay, so I appreciate the curiosity and I wish I could satisfy it, but for this class, you don't have to know it. So, what other questions? Okay. Questions going once? Questions going twice? Okay, we're going to wrap it up. There is not a midterm. There will probably be at least one more written assignment sometime this month. So I don't. Okay. On this, we're going to let you guys go, and I will see you tomorrow. Take care, and bye.